This is The Issue, and I am the Ghetto Man. We continue our series we call the Red Pill series on the Bill of Rights. This particular show is going to be on the preamble to the Bill of Rights. What is the Bill of Rights? Don't go away. We'll be right back. Okay, so today we're going to continue our Red Pill series. We're on the Bill of Rights now. We're going to start with the preamble. Yes, the Bill of Rights has a preamble, just like the United States Constitution. We're going to cover that today. Well, what is the Bill of Rights anyway? Well, the Bill of Rights are the first 10 amendments to the United States Constitution. Why a Bill of Rights? Well, at the time of the ratification of the U.S. Constitution, and in response to the concerns of the several states for greater constitutional protection for the inalienable rights of the people, and with the help of James Madison, who wrote them, a list of restrictions, a list of permanent prohibitions on governmental powers was established. At the time, there were two major opposing viewpoints. There were the anti-federalists who opposed the development of a strong federal government, wanting power to remain in the hands of a state and local governments, and the federalists who wanted a stronger national government. Now, one of the many disagreements between the federalists and the anti-federalists was that the Constitution lacked a Bill of Rights. A Bill of Rights that would place permanent and specific limitations on the power of the federal government. The Federalists, on one hand, contended that the Constitution didn't have a Bill of Rights. They believed that the people and the states retained all powers that were not specifically given to the federal government, which is true. Anything that was not specifically authorized by the Constitution was off limits to the federal government anyway. The anti-federalists, on the other hand, contended that because the people and the governments tend to forget things that are not written down, and there are people out there that would attempt to subvert those rights, given a chance, whether they were written down or not, that a Bill of Rights was needed to forever safeguard the inalienable rights that are so important to a person's life, liberty, and property. So a Bill of Rights was added to the U.S. Constitution as a permanent safeguard, signed, sealed, and delivered, guaranteed by a mandatory oath of office, which is a voluntary agreement between we the people and our public servants, was established to make sure that the inalienable rights enumerated within the Bill of Rights were to never be infringed upon by our servant government. The Bill of Rights are declaratory in nature and are restrictive clauses directed towards government only, and they do not create or grant the rights that are enumerated within them. It must be understood that the rights secured by the Bill of Rights existed long before the U.S. Constitution was even an idea. James Madison was a member of the U.S. House of Representatives at the time, and he went through the entire Constitution, making the changes in the areas that he felt were most appropriate. But he ran into several representatives that objected to the changes. Roger Sherman led this objection, claiming that Congress did not have the authority to make changes to the Constitution itself. So the changes that Madison made had to be ratified as amendments pursuant to the mandates of Article 7. 17 of the amendments were adopted by the House. The Senate approved 12, and in August of 1789, the 12 were sent to the states for ratification. The last state to ratify the amendments was Virginia on December 15, 1791. What was finally adopted are the first 10 amendments, the Bill of Rights, that are found in the U.S. Constitution today. Now, our founding fathers understood the importance of preserving natural rights, those rights that nature and nature's God gave to them. There are English documents like the Magna Carta, the Great Charter, and the English Bill of Rights, the Petition of Rights, and the Massachusetts Body of Liberties that had a great influence on the creation of the Bill of Rights. Some of the ideas that led to the writing of the U.S. Constitution go back some 5,000 years. The rights that are enumerated in the Bill of Rights are so fundamental that they exist whether there's a Constitution or not. Why? Because they are inalienable rights, rights that belong to you just because you're a human being on planet Earth. A gift from God to some and a gift from nature to others. These inalienable rights are yours and yours alone. No one or no law can alter or abolish them in any way. So what is an inalienable right anyway? Black's Law Dictionary defines it as inalienable rights, rights which can never be abridged because they are so fundamental. When it comes to the Bill of Rights, the only thing allowable by law, the only thing the government can do, if they can do anything, is to expand upon them whenever possible. Create more protection of those rights, not less. Thus, the first paragraph of the preamble to the Bill of Rights makes the intent of our nation's founders as clear as it can be. Quote, "The conventions of a number of the states having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in government will best ensure the beneficent ends of its institution." And that's taken from the first paragraph of the preamble to the Bill of Rights, which was ratified by the states December 15th, 1791. The Bill of Rights is a list of limitations, prohibitions, and restrictions on government powers, nothing more. Our founding fathers saw and understood the natural right of individuals. That is why the inalienable right to speak and worship freely is protected by the First Amendment's restrictions, prohibitions on Congress from ever making laws that infringe on the establishment of religion, the free exercise thereof, or abridging the freedom of speech or of the press. They also understood the natural right to be free from unreasonable government intrusion in one's person, papers, and houses and effects. And they knew that an amendment was needed to safeguard these inalienable rights, so the Fourth Amendment warrant requirements were established. In the U.S. Supreme Court case called United States versus Cruikshank, it's an 1875 case, and it can be found in the United States Supreme Court Reports, Book 92, and it starts on page 542. The court ruled and clarified that the rights enumerated in the Bill of Rights are not granted by the amendments themselves. The court also addressed the issue that the rights enumerated in the Bill of Rights are not dependent upon the Constitution for their existence. Why? As I said before, because an inalienable right exists outside of the U.S. Constitution's jurisdiction. The court made it clear that the amendments were restraints on the powers of the federal government, not on the creation or granting of the individual rights of a U.S. sovereign citizen. Okay, now let's take a look at the court's reasoning. Let's look at what I think is the most definitive and succinct legal explanation of the Bill of Rights there is. Now, in this particular quotation, it is directed to the right to keep and bear arms, but its application is the same for any inalienable right enumerated in the Bill of Rights. Quote, "The right there specified is that of bearing arms for lawful purpose. This is not a right granted by the Constitution, neither is it in any manner dependent upon that instrument for its existence. The Second Amendment declares that it shall not be infringed. But this, as has been seen, means no more than it shall not be infringed by Congress. Now, this last sentence here is very important. The court said, this is one of the amendments that has no other effect than to restrict the powers of the national government, or the federal government as we call it. And like I said, this comes from a case called United States versus Cruikshank. You see, the courts understand that the Second Amendment did not create or grant the right to keep and bear arms. All judges in every court know this. They all know this. They know that the rights referred to in the Constitution existed long before the Constitution was ever written. All that the 10 Amendments did is place additional restraint on the powers of the federal government concerning the natural, inalienable rights of the people. Under no circumstances can any government servant infringe on these rights, ever. Now, had the Constitution granted the rights enumerated in the Bill of Rights, the words granted or created would appear in the law. Instead, we find that in every amendment, every single one of them, the words nor, no, and not appear in the law instead. Now, as I said earlier, the Bill of Rights are declaratory in nature. They are restrictive clauses directed towards government only and do not grant or create the rights that are enumerated within them. So, if that's true, can the rights enumerated in the Bill of Rights be amended and or repealed? Okay, all of the rights contained in the first 10 amendments exist independent of the Constitution. The rights enumerated in the Bill of Rights are independent from the amendments themselves. I want to make sure that you understand this. Not one right contained in the Bill of Rights was created by the Bill of Rights or created by the Constitution. Okay, let's take a look at Article 5 of the United States Constitution, which deals with making amendments to the United States Constitution. Since the Bill of Rights did not create or grant the rights enumerated within them, there is no authority under Article 5 granting Congress the power to amend or repeal a right or law that the Constitution itself did not create. Understanding this, if any of the amendments in the Bill of Rights could be repealed, all it could do, if it could do anything at all, is remove the secondary restraint, the right itself being the first restraint, imposed on the federal government by the amendments. The rights that the amendments protected still remain, and they remain forever, as long as you are willing as a person to fight for it. So repealing any of the first 10 amendments would not affect or eliminate any of the rights enumerated in them whatsoever. And since many of the 50 states mirror the rights enumerated in the Bill of Rights as part of their constitutions, the existence or non-existence of the secondary restraints placed on the federal government by the Bill of Rights would have no effect on any of the inalienable rights secured by the people in the states with constitutions that protect those rights as well. So based on the law, the intent of the framers, Supreme Court rulings, U.S. history, and a mandatory oath of office to uphold and defend the U.S. Constitution from all enemies, foreign and domestic, a voluntary agreement made between we the people and our public servants. None of the inalienable rights, not one of them, that are secured by the Bill of Rights can be amended or repealed under any circumstances. This is why the Bill of Rights is in our Constitution in the first place, to protect us from a domestic enemy that would attempt to curtail our inalienable rights by law or otherwise. I am the Ghetto Man. Thank you for watching. In the next show of this series, we will cover the First Amendment, and the restrictions that it placed upon our servant government. Stay tuned. If you're politically correct, then you're legally wrong. And if you're not part of the solution, then you are the problem. And I have one other thing I want to say. Playing it safe is the most dangerous thing that you can do. Please subscribe to my channel, and please share, and long live the Republic.